During the 1960s, a legal aid movement was created by various law societies. Indeed, police interrogation practices raised questions and concern. These were considered by some to be barbaric and unjust. Coercive interrogation tactics were known in the period as the third degree. And during this period, the Supreme Court was called the Warren Court, after a Chief Justice named Earl Warren. The period is recognized as the highest point in the judicial power that has receded ever since, but with a substantial continuing impact.
So today we are going to talk about Miranda versus Arizona, which is a landmark case of the United States Supreme Court, argued between February the 28th and March the 1st, 1966, which ruled that a suspect must be informed to consult an attorney and not to self-incriminate before being questioned by the police. So it involves the Fifth and the Sixth Amendments.
On March 30th, 1963, Ernesto Miranda, a man who had previously been convicted for abducting and rape of several young girls, was rearrested by the Phoenix Police Department for the same facts. He is charged with kidnapping and raping of an 18-year-old woman 10 days earlier. After 2 hours of custodial interrogation, the alleged perpetrator confesses the fact. He states, I quote, "I do hereby swear that I make this statement voluntarily and of my own free will, with no threats, coercion, or promises of immunity, with full knowledge of my legal rights, understanding any statement I make may be used against me." However, before he confesses the fact, he was not informed of his right to have an attorney, he was not informed of his right to remain silent, nor of the fact that his statement can be used against him during the procedure.
So the Supreme Court's decision in Miranda versus Arizona consolidated 4 different cases involving custodial interrogation by establishing a set of arrest procedures, including the famous right to remain silent. They were Vignera versus the United States, Westover versus the United States, and California versus Stewart. So, like Miranda, defendant Michael Vignera and Carl Westover confessed to crimes after extensive custodial interrogation without being advised of their rights. In each of the 4 cases, the defendant was interrogated by police officers, detective, or prosecutor in a room where he was cut off from the outside world. In none of these cases was the defendant advised of his rights at the beginning of the interrogation process. Then each interrogation in each case resulted in oral confession, and in 3 cases signed statements that were used at trial.
While the police officers didn't want the accused of his rights, the Constitution provides several safeguard procedures. The Fifth Amendment of the Bill of Rights states that, I quote, "No person shall be compelled in any criminal case to be a witness against himself." And the Sixth Amendment of the Bill of Rights states that, I quote, "In all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense." In the first trial, Miranda's confession was admitted, so a court convicted him of kidnapping and rape. Then the Supreme Court of Arizona affirmed the conviction, so he lost in appeal too. Like Miranda, defendants Carl Westover and Michael Vignera confessed to crime after extensive custodial interrogation without being notified of their rights, and their convictions were affirmed too. But the Supreme Court of California reversed the Roy Allen Stewart's conviction because the record was silent on whether he had been advised of his rights. So the US Supreme Court accepted these 4 cases to determine what kinds of custodial interrogation procedures were required to adequately protect the Fifth Amendment right against self-incrimination.
So the issue was whether statements obtained from an individual who is subjected to custodial police interrogation are admissible against him in a criminal trial, and whether procedures which assure that the individual is accorded his privilege under the Fifth Amendment right to the Constitution not to be compelled to incriminate himself are necessary. In other words, in a custodial interrogation, are procedural safeguards required to protect the Fifth Amendment right against self-incrimination.
On June 30th, 1966, the court held that without a certain hallmarks warnings regarding the right to an attorney and the right to remain silent, statements made during the custodial interrogation were inadmissible at trial. I quote, the prosecution may not use statements, whether exculpatory or inculpatory, stemming from custodial interrogation of the defendant, unless it demonstrates the use of procedural safeguards effective to secure the privilege of self-incrimination.
So, writing for 5 justices majority, Chief Justice Warren concluded that, I quote, prosecutors can't use statements obtained from custodial interrogation without procedural safeguards. The court gave a definition of custodial interrogation. It occurs when law enforcement officers question a person who has been arrested and taken into custody. I quote, by custodial interrogation, we mean questioning initiated by law enforcement officers after a person has been taken into custody or otherwise deprived of his freedom of action in any significant way. So Chief Justice Warren described custodial interrogation as inherently coercive because cutting suspects off from contact with the outside world creates an environment ripe for intimidation, so police officers can easily prey upon individuals' weaknesses at the expense of individual liberties. For example, Miranda suffered of mental illness and Stewart has dropped out of school in the 6th grade.
So according to the court's ruling, procedural safeguards needed the right to have an attorney, and if the accused cannot pay, one will be provided for free, the right to remain silent, and the information that anything said can be used as evidence of guilt. Any waiver of these rights must be voluntary. If the person refuses to answer, the questioning must stop. And if he answers to the questioning, that doesn't mean he waives these rights, and he will always have the right to an attorney and to stop the questioning at any time. So after establishing these principles, the court held that the statement of all 4 men were inadmissible. The court reversed the conviction of Miranda, Westover, and Venera, and affirmed the Supreme Court's reversal of Stewart's conviction.
Justice Clark dissented from the court's judgment. He wrote what we call a dissenting in part opinion. I quote, a totality of the circumstances test should be used to evaluate whether each statement was voluntary. So this test would have been employed by Clark because lacking empirical evidence on the impact of the court's procedural safeguards, Clark worried the majority had gone too far. The dissenting opinion was written by Justice Harlan, joined by Justice White and Stewart. They also dissented because, according to them, I quote, the majority's procedures discourage any kind of confession. Even if the Fifth Amendment applied to pretrial custodial interrogation, it hardly supported the majority's strict procedures. A legislative reform could craft a better solution and would be supported by empirical data on the effect of any new procedures on law enforcement practice. Justice White also wrote his own dissent. In his view, no Supreme Court case law supported the majority's procedures. I quote, custodial interrogation are not inherently coercive. The majority's procedures will weaken law enforcement. So as we can see, the decision of the Supreme Court raised a lot of questions and doubts and divided opinion, and we will talk about it in the impact of the case.
To talk about the impact of this case, we can say that it's a huge victory for individual rights. Miranda was a consolidation of 4 cases. It was a radical change in American criminal law, and it has a significant impact on law enforcement in the US. Indeed, the Fifth Amendment of the Bill of Rights was understood only to protect American people against formal types of confess, threats, and contempt of court. But thanks to Miranda, the concept of Miranda warnings has been adopted by American law enforcement, which calls the practice Mirandizing. This concept is to ensure that the suspects are informed of their rights during the police procedure.
So police procedures were summarized in the Miranda warning. Police departments across the country distributed cards to their officers to recite to suspects, I quote, "You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. Do you understand the rights I have just read to you? With these rights in mind, do you wish to speak to me?" So now Miranda warnings are constitutionally required. We can also talk about President Nixon because 2 years later, he advocated reversing Miranda in his 1968 presidential campaign. He supported the Congress's passing of the Omnibus Crime Control and Safe Streets Act of 1968, which purported to abolish Miranda in the federal system. But the case, Dickerson versus United States in 2000, ruled that Miranda warning and the Miranda rights are still constitutionally required in federal cases.